KIPI. And let me start with a brief history of where KIPI has come from. The act that was enacted in 2001. And in terms of what KIPI does, it implements two acts of parliament. One is the Industrial Property Act of 2001 that relates to registration of patents, industrial designs, utility models, and technovations. The other act is the Trademarks Act that relates to registration of trademark relating to goods and services. Before 2001, when KIPI was established, previously it existed as Kenya Industrial Property Office that had been established in 1989. And the establishment of KIPO in 1989 was necessitated by an institution called KEMRI when they came up with an invention of a drug that was called Kemron. And then at that time it was realized that there was no law in Kenya that would have allowed KEMRI to apply for a patent. Before that, the law requires that once you come up in an invention in Kenya, the law was dependent on the UK system, that an applicant would be required to apply for a patent protection of the invention in UK. They go through the UK system, and then once a patent is granted in UK, then they will apply for it to be registered in Kenya at the AG office. And let me say from 1913 to 1989, there was a system where patents and trademarks would be registered at the AG chambers. But that changed in 1989 as well as in 2001. Let me talk about the mandate of KIPI as provided by the law is to promote inventive and innovative activities and to facilitate acquisition of technology. And that is done through the grant and registration of various IP rights, namely the patent, utility models, industrial designs, and trademark. And we talk about the promotion of innovation. KIPI is one of the agencies that do that. There are other agencies that also with a similar mandate to promote innovation. We have an organization like Kenya National Innovation Agency. They also have a role in terms of promoting innovation in the country through different activities. For KIPI is about registration of those 4 IP rights. And how it works is that once you have your rights registered, you have the exclusive rights in the market. And once you have the exclusive rights, it's possible that you can recoup the investment in terms of your investment in research and development by probably charging a higher price in the market. And that way, that's how KIPI does the promotion of invention and innovation. And we look at some of these titles that we register. The functions of KIPI, a number of them, is to grant and register patents, utility model, industrial designs, and trademarks. The other function is to screen technology transfer agreements and licenses. Yes, you may have your IP right, you've gotten a patent, industrial design or trademark, but then for you to exploit your IP rights, you can either do it yourself, make the products, and sell them in the market. You can decide to license somebody else to do that, or you can transfer your rights. You can sell your patent right to somebody else who probably has the capacity to develop the products and services and put them in the market for people to buy. In other words, there is a business aspect. Once you have your rights, you have to convert them to a business such that you are benefiting from your rights. The other function is KIPI provides industrial property information to the public in the sense that we run some activities, IP awareness activities, as well as providing information on the technologies that are protected, and therefore you cannot infringe on those rights because they are protected. Or we can provide the status whether those your invention, there is a similar invention protected in Kenya, and if not, then you can exploit that invention that is not protected in Kenya. We also run activities to promote inventiveness and innovativeness, and we organize and conduct training and competition and rewards to inventors. Then we look at the various titles that we grant and what is it that they protect. When you talk about patents, they relate to protection of inventions. And what constitutes an invention is defined in the law, that it's a new solution to a problem in the field of technology. So it's very specific to what you can get a patent for, a solution to a problem in the field of technology. And that invention has to relate to a product that you have created or a process for creating that product. And in addition, the product or process must be capable of being made in the industry. So when you talk about the solution, note that is not every solution that you can get a patent for. For example, if you have a solution for solving a domestic problem, that you cannot get a patent for that because of the definition that is there. Or a social problem, you may not get a patent for it because what you can patent is already defined in the Act is a solution to a problem in the field of technology. It's about progressing technology. The technology may exist, but then you can work on it and improve on it and also get a patent. The other clarification is that the things that you can patent the invention is something that can be made in the industry or used in the industry. It's not everything else that you can get a patent for. It's very specific. I have an example of a patent there on the screen that was granted to Defense Forces Technical College in 2012. It's a mobile field kitchen. You can see the drawings there. And that apparatus was used for some time back because the KDF were able to use it when they went to Somalia. So it's a mobile and produces a lot of, it can cook a lot of food using very minimal amount of fuel. And from the discussion we've had with them, they are making this kind of devices for big institutions. For example, the schools and prisons was very useful. And from the discussion with them, I think one unit of this, it's a big thing. That kitchen, they were selling at 1 million Kenya shillings. So you can see the role of the IP system, more so the patents, that you can be able to make things and sell them in the market and prevent other people from infringing on your rights. And the requirements for protection or getting a patent protection, the first one is you got to submit a patent application in countries of interest. IP protection, most of the patents, or what KIPI does, they are territorial. The patent you apply and get registered at KIPI is only valid in Kenya. It doesn't apply in other countries. And therefore, it's based on you somebody submitting an application in the countries of interest. The other requirement is the disclosure of the invention, where the applicant is required to provide detailed description, written description of the invention. You got to disclose what is that you have invented so that you get the protection in exchange for the disclosure. The other requirement that the invention, once you receive it, it'll go through a process. Ultimately, the idea or the goal is to check whether your invention meets the requirement, whether is it new, not only in Kenya, but throughout the world. The other one is the second requirement, your invention must be inventive, in the sense that your invention should not be obvious to a person in the same field. And the third one is that the invention is something that can be applied in the industry, can be made or used in the industry. So those are the requirements for getting a patent. And we look at the benefit. What are the benefits once you get your patent rights? How do you benefit? One is the exclusive rights to prevent other people from exploiting your invention by making the product or importing the product, selling the product, or using the invention to make something out of it. Any person performing these acts, if they are making your invention or importing what is contained in that invention or patent, then they'll be deemed to be infringing on your patent rights. And the law provides for a mechanism on which you can approach the court to settle the dispute or to enforce your rights in court. And we have various organizations that are responsible for enforcement of those rights. The rights may be assigned or licensed so that you can, if you have a patent, you can license somebody else to exploit the invention. You don't have to do it yourself. You can license somebody. The other one you can assign, that is you sell off your invention or your patent for somebody to own it and exploit it. The other benefit in terms of the period of protection, the law says that a patent lasts for 20 years from the date that you submitted the application at KIPI or any other country. However, the 20 years are subject to payment of annual fees. Every year you're required to maintain that patent by paying some little amount of money to maintain that patent. The second category of rights that you can obtain at KIPI are what we call the utility models. And these are innovations that give some utility or advantage that was not available in Kenya before you apply to be granted those rights. Or improvement that may not qualify for patent protection. Remember what I've just said, for patents there are 3 requirements. It has to be new, that is your invention. It has to be inventive and industrially applicable. For utility model, the requirement is newness and also industrially applicable. And the requirement for obtaining the UN protection is submission of a country, more or less like when you're applying for a patent, and also including the disclosure of the invention by providing the detailed information of the description of the invention. For utility models, the benefit include the 10-year period of protection and the exclusive rights to the owner to make or use the invention in Kenya, if that is registered in Kenya only. If you may decide to go the East African route, there is a regional organization based in Harare, Zimbabwe, that you can obtain a patent that is valid in a number of countries. I think currently is about 22 countries across Africa that you can apply and get registration of either a patent or utility model in those countries. And of course, the right to take legal action against a person who infringes on your rights. And also, they can be licensed or sold to other people. You can transfer your rights to somebody else. And an example of a registered utility models, a portable burner device. There's a lot of activities that is happening at Strathmore University. There's an organization, Kenya Innovation Center. There is a lot of research going on in terms of this kind of burners that use, just improvements of the existing burners. And we are seeing a lot of activity coming from that center. In terms of the applicants, most of their utility model applications are filed by Kenyan residents. Almost 99% are filed by Kenyan residents. The foreign applicants, very few activity in terms of utility models, but very highly active in terms of patent registration. And the most active applicants include the individuals, a lot of individual applicants who are filing utility model applications, SMEs, and also TVETs. We are seeing a lot of applications coming from those three categories of applicants. The third type of IP are the industrial designs that relate to protection of appearance of products in terms of the shape of a product, ornamental features of a product, or combination of both. You may have a product with combination with a new shape and also ornamental features. And the features that make a product attractive or appealing to consumers, and also the features that add commercial value to a product. A number of examples there. We have a display stand on the right. On the left, that is a perfume bottle in the middle. I think maybe somebody can remove those things that are appearing there, please. Yeah. Thank you. A perfume bottle with that shape, registered some time back. So, and in terms of the period of protection, is 15 years for this bottle in the middle. The rights have expired, and anybody is free to make use of it if they have the capacity. A sealing board relating to that pattern that is shown there. Yeah. Other examples is portable solar power kit, and probably you've seen them in the market. If you go to the supermarket, the devices are available. They have been registered at KIPI. There's another window, if somebody can minimize it, it'll be helpful. That the casing for a power solar lamp. In terms of the process of obtaining industrial design registration, again, you're required to submit an application and also the graphic representation of the product. In terms of the drawing or photograph, the ones that we have just seen previously. And the requirement for registration design, it must be new. And also identical or similar design must not have been disclosed to the public before you applied for registration of your design. In terms of the benefit of design registration, the law gives a maximum of 15 years period of protection and the right to prevent other people from copying the design or offering for sale products embodying the design that is registered. The other benefit is you can take legal action against any other person who infringes on your design. And also the positive right of ability to license your design to somebody else or to sell it off to somebody else so that they take complete ownership. The fourth right that we can obtain at KIPI are the trademarks, and these are common word out there. They are called the brands, and these are distinctive signs that are used to identify goods and services of one enterprise from those of another enterprise, and to distinguish goods or services of one enterprise from the other. We have the examples of what we call the trademarks. A trademark can be a word. For example, you have the Jogos and Hodari and Soko for maize flour. You also have words like Keringet, Dasani and Excel for bottled water. A trademark can be in the form of a device. For example, those logos. The left one, I think we all know about it.